Now, interestingly, the Subhash Chandra Agarwal case versus CPIO Supreme Court is a long case which was in relation to the declaration of assets and liabilities by judges to the Chief Justice of the Supreme Court of India. This has been quite a long issue that was taken up at the Delhi High Court and later on even by the Supreme Court, as the case may be. Now, in 2009, RTI activist Subhash Chandra Agarwal sought copies of a resolution that was passed in 1997. This was a resolution of 1997 which required all judges of the Supreme Court to declare their assets to the Chief Justice of India. And he wanted a copy of that resolution, and he also wanted to know whether judges are actually declaring these assets or not. So what he sought was details of the assets of the Chief Justice of various high courts. Unfortunately, this request was denied by the CPIO, and later on Mr. S.C. Agarwal approached the Central Information Commission, and the CIC directed that there should be such disclosure of such information regarding the personal asset of the judges. Now, the order of the CIC was challenged before the Delhi High Court, and it was held that the Chief Justice of India is a public authority under the Right to Information Act, and the CJI holds the information pertaining to the asset declaration in his capacity as the Chief Justice, which is a public office, right? And hence, the information pertaining to such declaration, which is at the CJI, must be information that should be provided under the Right to Information Act. However, the CJI in this case held that the said information is held in a fiduciary capacity. And hence, under section 81J, this can be treated as an information that is in trust and confidence, and hence the said information shall not be available under the Right to Information Act. So, in the S.C. Agarwal case, you realize the use of section 81E and section 81J, which is in regarding to personal information, which were used to deny the said information, as the case may be. However, you know that right now the office of the CJI has been declared to be a public authority. We have already discussed this matter. And after having discussed the said matter, once it is a public authority, then the second question is whether the information held is in a fiduciary capacity or is personal information, and whether the said information should be provided or not. However, when you apply the Girish Ramchandra Deshpande's case, it's a Supreme Court judgment of 2013, you will notice that assets and liability statement of public servants are personal information, and hence they shall not be provided under the Right to Information Act. And judges are also public servants, and hence such information cannot be accessed under the Right to Information Act right now. The second interesting case on fiduciary relationship is the CBSE versus Aditya Bandyopadhyay case. A very celebrated case, a case that has been used as a precedent, quoted in several other cases after 2011, decided by the Supreme Court. And again, it involved the Central Board of Secondary Education. And this was a case where the candidate got his marks, but was very disappointed, right, with his marks. So what he requested the Central Board of Secondary Education was, can he get to see his answer book? So what he wanted to do was to inspect his answer book and get a copy of the same. So, naturally, being a candidate who has, taken part in an examination, you are always bothered about the fact that whether the marks have been properly calculated, whether the totaling has been done or not, whether all the answers have been checked or not. So this is kind of a anxiousness that every examinee has, right? So they would definitely want to check whether the answer book copy has been properly evaluated. And hence he wanted a copy of his answer book, and hence he made an application to the CBSE, and the CBSE rejected the same way back in 2008. Now the reasons for the rejection were somewhat like this. They said, that is CBSE said, that the information sought was exempted under section 81E, since CBSE shared a fiduciary relationship with the evaluators, and it has a duty to maintain the confidentiality of the manner and method of evaluation. This is what the CBSE defended. Secondly, the CBSE also said that the examination bylaws of the board provided that no candidate shall claim or is entitled to revaluation of his answer book. So what is the purpose of inspection when there is no revaluation? Or he has also given a declaration that he will not seek inspection of the answer book copy. Right? So once he is given this declaration, what is the point of using RTI to seek the same? And lastly, the Central Board of Secondary Education said that there is no public interest that warrants the said disclosure of the information. Right? So unless there is a public interest, why should the said information be disclosed, is what the CBSE said. Because in most cases that you will notice, whenever there is an information that is of commercial confidence, information that is held in a fiduciary capacity, information that is personal, unless there is a larger public interest, most of this information shall be exempted and shall be denied. The CIC, however, gave a decision, and the CIC looked into the rules and regulations of answer booklets within the CBSE, and they did come to know that CBSE only maintains these answer books for a period of only 3 months. So in case you want a copy, or you want to check, or you want to do retotaling or revaluation, it's only within 3 months. So after that, they destroy these records. So their record maintenance of answer booklet copy is only for 3 months. So the time is the essence in this case. And within that time, the applicant had actually sought a copy of his answer booklet. Now, the High Court Divisional Bench heard and disposed the writ petition that was filed, in this case, CBSE versus Aditya Bandyopadhyay, and they relied on a very interesting case called the West Bengal Board of Secondary Education case. They held that evaluated answer books of an examinee who writes a public examination, which are conducted by statutory bodies like CBSE and others, or say by a university and so on and so forth, they are actually a document defined under the Right to Information Act. They are a manuscript, they are a record under the Right to Information Act, and hence you will notice they fall within the ambit of information under section 2F of the Right to Information Act. And hence what they said is that when an examinee wants to inspect his evaluated answer book, especially in a public examination, or wants to take a certified copy thereof, I think he should get a right to the same. And this is necessary to ensure transparency and accountability of the whole examination and evaluation system, especially when it is conducted by the public examination institutions. And most importantly, the court held that when it comes to holding answer booklets, the evaluated answer booklets, kindly note, right? The board is not in a fiduciary relationship with the examiner. So interestingly, the examination authority is not holding the answer booklet after evaluation in any fiduciary capacity. And hence, if they cannot hold, or they are not holding the same in a fiduciary capacity, they cannot withhold the said information under section 8(1)(e), is what the divisional bench of the High Court had to say. So I think in the Aditya Bandyopadhyay case, very importantly, the judges favored disclosure of inspection of answer booklet copies, especially to individuals who are seeking their own answer booklet copies. And they said this will secure accountability and transparency in the working of the public authorities, and it will give equal opportunity to people. And I think what it would help is in bringing about a different system vis-a-vis public examinations altogether. I think that is where you will notice that after evaluation, I don't think the answer booklet copies are held by the examination authority in a fiduciary capacity. So fiduciary capacity cannot be extended beyond the traditional sense of those relationships in which it is defined and interpreted to mean as fiduciary. A relationship of trust, a relationship of confidence exists only between certain categories of individuals, and it cannot be extended beyond the same.